Hello, St. John's. My name is Donna Furey. I'm an alum, and I'm also an elder law and trust and estates attorney. And my job here today is to tell you a little bit about trusts and how they can be helpful and beneficial for estate planning, tax planning, Medicaid planning, charitable giving, so whatever your needs are. The basic and the most important thing about trust is that it keeps us out of the courthouse. Going to the courthouse can be a pain in the neck, and we want to try to avoid going there if we can. And also we can have a lot of protections by not going there. Very often, the reasons that we don't want to go to the courthouse could be that we think someone's going to challenge whatever we want to do. In which case, by going to create a trust, they have to drag us into the courthouse in order to try to challenge the trust and whatever's been done with the trust. Also, very often I find it's very helpful for people who don't have family. So if they don't have siblings and their parents were only children, someone like that is going to, and they're not married and they have no kids or various things like that, there's going to be a problem because now we have to prove who all their blood relatives are if we go to court. So these are some of the reasons why, or if you want to cut somebody out of your will, that's also another reason why we want to maybe use a trust. So I'm going to give you a little idea about how, the types of trust that we have. So a trust is a legal entity in which the trustee is the person who is in charge of whatever we put into the trust. And if it's a revocable trust, that means you're in charge. Okay, that means that you are controlling whatever's inside the trust. Again, there's certain situations where I would highly recommend that. Also, the thing about charities is that if we have charities in our states that we want to leave gifts to, then what happens is the Attorney General will be involved if we go to court. It's not that I don't like the Attorney General, but if I don't have to deal with the Attorney General, I prefer it. And so I would highly recommend trust for someone who wants to leave to charities, because the job of the AG is to actually, protect the charities and make sure the charities get what they want, which is a great thing. I'm not saying that it isn't, but they can be tough. So we try to avoid dealing with them as well. And so the idea here is this, that also on top of that, with a trustee, a trustee doesn't make the commissions that an executor makes. So if you're trying to keep the expenses down on your estate, after you pass, even though you might pay a little bit more for a trust now, it's going to save you a lot of money in the end, and it also saves you time, because going to court is time. So the types of trust that we have, the main types are revocable and irrevocable. Again, revocable means you're pretty much in charge. Usually you can be the trustee and you're controlling whatever's going on. And then after you pass, we have a successor that's going to step into your shoes and kind of actually act like an executor and finalize whatever your wishes are. With an irrevocable trust, you cannot be in charge. And so with this type of a trust, you would have, most of the time, relatives, friends, somebody that you trust to be the trustee of that trust. These types of trusts can be very helpful to us for Medicaid planning. Again, you can leave your assets to whomever you want. It could be to charity, it could be to friends, it could be to family. But, in an irrevocable trust, you are no longer kind of in charge. You usually do have some powers inside the trust, and if necessary, there are statutes in New York State, at least, that would allow you to even revoke the trust if need be. Again, depending on how the trust is worded. But usually an attorney is going to put some protections in there so that you still have some control, where you can change beneficiaries, you can remove trustees, and different things like that. There's a lot of different provisions that you could put in. Which either trust and then there's other types of trusts as well. One of them that can be very helpful for disabled people is a supplemental needs trust. This kind of trust makes sure that if you want to leave assets, and you can even have an irrevocable trust or a revocable trust that says, I want to leave a certain amount of assets to someone who's disabled, so you can have a trust within a trust. So for disabled people, for minors, okay, because we want to make sure minors, we don't want them to get, in New York State, the legal age is 18. So if an 18-year-old inherits a lot of money, the first thing they're going to do is they're going to go buy a car, right? So, so we just want to keep them in line a little bit. And so with disabled people, we want to make sure they continue to get whatever their disability benefits are. If they receive a lot of money outright, it could throw them off their benefits. So we want to, prevent that. So, there's a lot of good uses for a trust. Another type of trust is a charitable remainder trust. So this is a type of trust that is irrevocable, and you would put an asset into the trust, and at the end of the day, you would get maybe income from whatever asset you put into the trust. So you'll have a fixed income that comes in annually, or it could be flexible. And at the end of the day, the charity will get whatever the asset is that you put into this trust. Again, this is good for tax planning. So, that's something that's good and helpful for that. I mean, tax planning can also be done with trusts. So, right now in New York State, it's like 6.1 million each person can have and you won't have any estate taxes. It's 11 million, or more for each person for the feds. So right now, to fall within these ranges, most people do fall under those ranges, so we're not going to have estate taxes. However, sometimes you can be close to the edge. So you might not have, so the feds, you might not meet their problems, but in New York State, you might. Because, real estate is very expensive in New York State, and it's getting higher and higher. So these are just some of the aspects of irrevocable and revocable trusts, and supplemental needs trusts, and charitable trusts that can be very helpful to you in your planning. Usually when I do a trust, I also have what I call it a pour over will. And so basically we do a will as well that says anything that slips through the cracks, means that I didn't make the beneficiary of the trust, or I didn't put the assets I was supposed to put into the trust. Usually, that's something that the person who owns the assets needs to do. An attorney can help you with that if that's what you want. And most of the time, I usually help people put their houses into a trust, an irrevocable trust, so that I can protect it in case they need to ask for Medicaid sometime in the future. Because when I put a house into a trust, usually the trust is considered to be what's called a grantor trust, and I usually specifically state that. So what does that mean? That means that any assets that I have in the trust, it could be revocable trust, it could be an irrevocable trust, will not pass to the beneficiaries until I pass away. So I still have some rights in those assets that I've put into the trust. So the pour over will basically says that if I forgot to put a beneficiary on something, or if something slips through the cracks, it's going to go. Then we have to go to court with the will, and then we get control over it, and we throw it into the trust, because we want to have just one vehicle to deal with all of our assets. We don't want to, have a big giant mess on our hands, because we want it to be the way you want it to go. I think that's very, very important thing to think about. What other things? So step up in tax basis. So basically, when I do put a house into a trust, the beneficiaries will receive that asset at the date of death value, because it's a grantor trust, because you have these rights while you're alive in it. They will receive it at the date of death value. So that's what we call a step up in the tax basis. For example, if I bought the house for $100,000 and it's now worth $1 million, if they will receive it at the $1 million mark. Okay, there will be no capital gains on that asset. Stock, stock is a little interesting. To transfer stock, you need to really be working with your financial planner probably, because we want to make sure it's an in-kind transfer if we're going to try to put it into a trust, because we do not want to trigger the grantor, to have to pay any type of capital gains, because when you change the name on a stock, very often that could trigger capital gains. So I think, just to review, the important things here is that a trust keeps us out of the courthouse. Right now in New York State, courts are just, they're backlogged. It's taking years, months, and if you have problems and there's challenges, it could take a very long time to get through the courthouse. So that's the main reason why people do trust, just for ease of purpose. And it can be protections. So you can protect yourself from Medicaid, you can make sure disabled people are being taken care of, you can make sure your charitable giving is being done with the least amount of problems, okay? So it goes directly out to those charities. You can make sure that, you're doing your Medicaid planning, which I can't stress enough, but that's for another talk, because it's a lot that goes on there with that. So with that, I'm going to say goodbye, and I wish you the best of luck, and good luck with all of your planning.